Hi, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. The series covers 4 fundamental questions about property and property law. And today we're talking about the first question: what is property? We're also touching a little bit on the third question: what can we do with property? If you watched episode 2 about the Blackstonian bundle, you might have heard me talk about the different sticks in the property bundle. Chief among them, the right to possess, the privilege to use, the right to exclude, and the power to transfer. But one right we did not talk about is the right to destroy. And I guess my question for you is, do you think that people who own property should be able to destroy it? If you do, the law doesn't necessarily agree with you. So to illustrate this, let's go to a case, Eyerman versus Mercantile Trust Company, which was decided back in 1975. It involved a beautiful house in St. Louis. But before I talk too much about the house itself, I want to talk about its context. Where was it located? It's located on Kingsbury Place, a beautiful private street filled with 2- and 3-story homes, Beaux-Arts architecture. We're in the middle of a central city, but again, we're on a private street. So what is a private street? It's a street owned by people neighboring it, so neighboring property owners, and it's covenants or restrictions on their properties that require them to pay for maintenance of the streets. So you might be asking yourself, why might anybody want to live on a private street? People see them as a good way to protect their property values, people who don't mind paying for the upkeep. At this particular time in St. Louis, private streets may have been seen as a way to escape from the stresses of St. Louis and the whole. At the time of the case, we're in the 1970s. We're in the midst of white flight. There's fewer dwelling units in the city in the 1970s than even a decade earlier. We're in in a period of a lot of disparities between Black and white, between rich and poor, city and suburb, and that's the context of this case. So now let's get into this case, and probably the first question you might have is, who is Louise Johnson? So Louise Johnson passed away, and in her will, she said, she's the owner of this house, she says that I want my house to be raised and my heirs should get the proceeds. Her attempt to control property beyond her death, we call in property law the dead hand, so people reaching beyond the grave. So if you think about this provision in her will, who might object? And the first group that objects is the neighbors. Why do they care? Because raising the house would reduce their own property values. At the time, the house as it stood was about $40,000. And if she had raised it, it would have been just worth $650,000. Johnson's heirs lose out too. It's important to note that at the same time as this case, historic preservation designation was pending. So what that means is that it was possible that the property would go on a register of historic places. It's clearly a historic house in a historic neighborhood. Just something to keep in mind as we continue the discussion. We can see that the dead hand directive isn't good for anybody, not the neighbors, not the heirs, not the city as a whole if this property has historic value. So what does the court do? It really agrees with the neighbors and really society and society's values as a whole. It says that her decision to raise the property is contradictory to public values. It says that her decision is arbitrary and capricious. It calls into question perhaps her judgment. As a result, the court issues an injunction to prevent the demolition. But digging a little deeper, there are a few questions raised by this case. So first, is this really a matter of taste? Many people may not have cared so much about this property if it were a factory on the edge of town, or maybe even a house in a blighted neighborhood outside of this enclave of private streets. Second, what does the case say about our legal system that neighbors have the power to sue to stop property owners from doing something to their property? Would they have had the same power if she was still alive and pulled a demolition permit to demolish the property? The dissent in this case notes that the agreements creating the neighborhood and the private street provided for the provision of vacant lots. In other words, this might have been something that was well anticipated by the people who originally set out the subdivision. Another dimension here is whether this estate was historic. Had it been designated historic, it's possible that some principles of historic preservation law might have come into play to delay the demolition. So third big question, is this really about the concept of waste? So think about the interior details of the house. Look at the quality of these. Look at the house as a whole, its central location, its level of detail. It's worth now over $1 million. We think about the principle of waste when we talk about estates and land, which we will do in this series. Property law generally tries to avoid waste, but should we do it in every instance, or should we just do it when there's harm to society as a whole? Constraints on the right to destroy go beyond just buildings. There's also such a concept as artist moral rights, where fine artists can prevent the mutilation or destruction of their work, even by the owners of the artwork. In these types of laws, we've really made a choice about whose rights we value. In that case, the artist's rights, the rights of the creator, rather than the title holder. So you may want to consider public policy rationales behind limitations on the right to destroy. But in any event, it's important to know that this case illustrates, once again, that the right to property is not limited. So I'll leave it there. I'll look forward to hearing from you through Twitter or on my mailing list, through my website, which you can sign up at. So see you next time. Thanks again.